The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good afternoon. Welcome to the oral arguments of the Kansas Supreme Court. I'll now ask Mr. Doug Shima, the clerk of the appellate courts, to please call the afternoon docket.
Thank you, Your Honor. May it please the court. The 1:30 p.m. docket for Tuesday, February 2nd, 2021 consists of one case. Appeal number 120863, State of Kansas versus Archie J.P. Dooley, McPherson County, briefs both sides. The appellant has reserved 2 minutes rebuttal time. Your Honor, we are ready to proceed.
Thank you, Mr. Shima. Counsel, would you please state your appearances?
Yes, I'm Ryan Edinger, Assistant Appellate Defender, appearing on behalf of Archie Dooley, defendant and appellant in the present case, and present and ready for argument.
May it please the court, the state appears by Chris Ailslager, Deputy Solicitor General, ready for argument.
Thank you, counsel. Mr. Edinger, you may begin.
Thank you, Your Honor. May it please the court, I'd like to give the court and our audience the benefit of a quick procedural, perhaps factual background as to, because this case has accumulated some mileage since it's been in the courts. On April 9th, 2012, my client entered a plea, Archie Dooley entered a plea to failure to register. The district court sentenced Mr. Dooley to 120 months, but granted probation for a term of 36 months. On December 17th, 2013, the state filed a motion to revoke Mr. Dooley's probation, alleging, among other things, that he failed to report and had apparently absconded. The district court held a full evidentiary hearing at that time in 2014, at which point my client stipulated to the allegations, and then he argued in favor of reinstatement. Essentially, he argued what are the underlying facts of this case, that he was in treatment in McPherson County. He completed that treatment, was ordered to get himself into the Oxford House, which was in Ford County. He went to the Oxford House and came up $50 short of whatever fee it is that they required him to pay to get in. At that point, he did not report to Ford County, his initial intake assessment appointment in Ford County. And about approximately 2 months or so later, his probation officer and the court then filed a warrant for Mr. Dooley's arrest. At that point, Mr. Dooley his probation was revoked, and he was ordered to serve his underlying 120-month sentence. That Dooley 1, I guess we could call it, eventually arrived before this court. In that case, the court remanded the case, instructed the district court to either make findings that are sufficient to bypass the, at that time, required imposition of 120-day or 180-day sanctions, or to go ahead and impose those sanctions. The record was unclear, even though the district court had imposed sentence, as to what basis the district court was bypassing the required sanctions at that period of time. Eventually, that case, and then we had another on remand, which is what brings this present appeal forward. On remand, we had an additional evidentiary hearing. The facts essentially remain the same that were developed at these first hearing and are largely undisputed. And so really what comes before this court then is the Court of Appeals then affirmed the district court's finding that Mr. Dooley had absconded and was permissible to bypass the sanctions regime and order him to serve his underlying sentence. The Court of Appeals affirmed, and I'm sort of here standing on the shoulders, I think, of Judge Atchison's dissenting opinion, where really the issue before this court now boils down to what does it actually, what the legal finding that Mr. Dooley in this case has absconded. In the first case, Dooley 1, this court pretty clearly laid out what is required for that. And it's clear that it's much more than failing to report for initial or one or two appointments. You have to hide yourself away, either within the jurisdiction, flee the jurisdiction. It contemplates a sort of active attempt to evade prosecution, arrest, or some other order of the court. And I've taken issue with this finding in this case. Largely, I think there's two principal things that really cut against the Court of Appeals finding and the district court's finding. Number one is that Mr. Dooley, after about a month or so, a warrant was issued, I think, late December 2014 or 13. And January 10th, I believe it was, Mr. Dooley walks into the Ford County Corrections Office and says, I'm here to, apparently, I mean, he said he quote him, I think in the transcript, was he was there to see what was now going on. At that point, he was, of course, arrested because a warrant had been issued. And so I think that's the first point, is it's hard to square the conclusion that he's absconded with the fact that he actually goes and turns himself in. Now, there's some indication.
What about his conduct prior to that time, where he stayed in a hotel? He knew he was supposed to report. He was in another place without informing his probation officer of his whereabouts. How close is that, or why isn't that a conscious intent to hide from or otherwise evade legal process? Just that conduct there.
Well, I think what you're kind of referring to there is this idea that his probation, and there's some, he said he stayed at a shelter, he said he stayed at a hotel, there's a little bit of both. But I think what you're getting at is this idea that, you know, the probation officer said he called him several times. And so that kind of led the Court of Appeals, I think, is where they're coming from, or resting their finding on, well, he's calling him, his probation officer's trying to call him. He knew he was supposed to report for that initial thing. Therefore, he's not complying. The problem is that there's nothing really in the record to support the fact that his probation officer says that he called him. There's no follow-up question. Does Mr. Dooley have a phone? Who did you call? Where did you call? I'd also point out the fact that his girlfriend notified him in some manner or whatever, that he was required to report. I think we'd have a much different situation if there was evidence that his girlfriend said, well, I know where he's at this residence, and officers respond to that residence, and shortly there before that, he's left. Mr. Dooley never left the jurisdiction. He was in Ford County the entire time. He didn't report, and that's repeated again and again in the Court of Appeals opinion. He failed to report. And that's not enough to meet that legal finding that he absconded. It has to be something more than just failing to report.
What, if we agree with you, what is the remedy that you're seeking? He's been incarcerated for about 8 years now. I don't know. He got a 120-month sentence. He was revoked in 2013, 7 or 8 years. I mean, what is the remedy here?
The remedy here would be this court would make a finding that the district court erred in that legal conclusion that he has absconded. And then at that point, it goes back to the district court. And I think it kind of ends up on Mr. Dooley's plate of, well, do you want another crack at a probation? I mean, I can't say for sure. Do you want to go back on probation? I doubt it. But at the same time, I would hope that, considering the fact that there's a legal error that occurred in 2013 that's had him put under sentence in prison rather than getting a sanction, another opportunity at probation, I would hope that he would get some justice and some relief on something like time served at this point.
You continue to, I think, try to put this in the cabin of a legal error. And I kind of like to explore that a little more, because it seems like Dooley 1 pretty clearly set out the test. And is there anything to lead us to believe that the district court didn't understand that test and
Yeah.
then took that test and applied it to facts and reached a factual conclusion?
Yes, in fact, there's something very clear that I'm happy I can point out at this point that does show that the district court didn't understand exactly the full ramifications of this court's instructions in Dooley 1. And that's that during that opinion in Dooley 1, this court specifically told the district court that the fact that Mr. Dooley stipulated in that original hearing could not be used subsequently to make the decision in the present case. However, if you look at the district court's ruling on the final page, I think of volume 6 of the transcript, he specifically says that I do find that the defendant did in fact abscond for the following reasons. The first reason that the district court uses is that Mr. Dooley admitted at the original probation hearing that he had absconded. So I think that's a clear indication for this court to see that the district court did not get that right. And the fact that the district court puts that number one, this first finding that supports his legal conclusion, is something he was specifically, or the court, I'm sorry, was specifically instructed not to do, I think should be remedied.
Does that then make it a question of law for us, or is it a remand for more factual findings without that?
I think it makes this a question. I think it's a clear question of law for this court. However, I think for actual disposition, it's going to have to be remanded again. At least in terms of this is going to have to go back to the district court for the real, this present court can fix the legal error, but it's still going to have to go back for a final disposition on the last component of this case.
So the legal error is that the district court considered the stipulation as to whether he absconded.
That's the legal error that then led to the ultimate legal error, which is the court's finding and the Court of Appeals upholding the legal conclusion that Mr. Dooley absconded. So it's kind of stacked on top of each other, if you will.
That's one of several findings, I believe. But if we set those aside, there are additional findings about not reporting, failing to update. But the one I want to hone in on is there is a finding that Mr. Dooley intentionally avoided updating and reporting out of fear of imprisonment or the sentence that he might be facing. My understanding is you don't suggest that there's not substantial competent evidence supporting that finding, but correct me if I'm wrong. And then my second part of the question, I guess, is why isn't that sufficient evidence to suggest, or at least infer, that he sought to evade legal process within the jurisdiction?
I think there is evidence of that. I wouldn't dispute that there's substantial competent evidence of that. I think what we get to then, and if this addresses your question, is this idea of motive, more or less. And I think Judge Atchison kind of touched on that in his dissenting opinion, saying that almost all of these brief failures to, as it was in this case, a month or two failure to report with nothing more, such as, the defendant knows he has an arrest warrant, leaves the jurisdiction, somehow knows that the police or his probation officer isn't en route to check on him and flees that, even within that jurisdiction, moves somewhere else. I think that there's always going to be that motive in a probation revocation case, because obviously, as Mr. Dooley was facing a 120-month sentence. But the salient fact is that Mr. Dooley, even though he failed, again, it's sort of a failure. And as Ashton says, most of the time these motives are going to be, it's sort of or intentional sort of failure. But I think, as he said, that still doesn't get us immediately to the idea that you've absconded, that you've done something to really hide yourself away, secret yourself, avoid detection, leave the jurisdiction, those sort of things, or even go beyond a certain time. When Mr. Dooley came in only a month after there was a warrant out for him. And I think that's really, really important it's very hard to square any conclusion that he's absconded with the fact that he walked in and said, "I'm here to report. You're awfully late, but you are here," I think is the critical fact. If that answers your question, Your Honor. I see I'm out of time. If the court does not have any further questions, I'll be happy to yield.
Any other questions? Okay, thank you, counsel.
Thank you.
Mr. Elslager?
May it please the court, Chris Elslager for the state. What this case comes down to really is whether or not there's substantial competent evidence to support the district court's finding that Mr. Dooley absconded. In the first Dooley case, when it came up here, this court said that absconding could be proven by showing the probation violator engaged in a course of action where he intentionally avoided probation supervision or evaded detection by his probation officer. And I think when you look at the totality of the evidence here, there is definitely substantial competent evidence to support that. It's more than just a single failure to report or missing one meeting. It really starts with at the very beginning when Dooley did not check into the halfway house where he was supposed to live. Now, he claimed that was because he didn't have the money to pay the fee or whatever, but the bottom line is he didn't go to where he was supposed to live as a condition of his probation, where his probation officers thought he was living. And at that point, he did not make any, after being rejected from the halfway house, he didn't make any effort to call community corrections or his probation officer and explain what happened and ask for help or advise them of where he was going to go or how to find him or where he was going to live. And then that continued. I mean, every day thereafter, he continued to fail to call them and let them know and report where his residence was. The duty of his probation was to maintain residence and report that residence or any change of residence to his probation officer.
May I ask a question, counsel?
Yes.
Thank you. So I understand what you're saying, but there's case law out there that says that absconding is more than a failure to report. Is that right?
Exactly.
Okay.
And
so what did Mr. Dooley do besides fail to report? Because he did violate the terms of his the conditions of probation by failing to report, and the statute says, hey, when you do that, we're going to impose these intermediate sanctions. It's only in this case when you're absconding more than a failure to report that you can bypass the sanctions. So back to my question. Sorry.
Well,
go ahead.
As I'm going through this, one, he did not go to where he was supposed to live.
He didn't report.
To where he was supposed to live, that he didn't advise his probation officer that he wasn't living there or what his current living arrangement was day after day after day. Then he had a scheduled meeting with his probation officer in December, and he intentionally did not go to that. He skipped that meeting, and then continued then for the next, all of December and into January, perpetuating this continuous evasion, essentially, of his probation officer, not telling the probation office where to find him, not getting in touch with them, not being where he was supposed to be. And I think what is critical too is that it's not just, he didn't just fail to report. He didn't just miss a meeting by inadvertence or by accident or be out of as a result of something out of his control. It was intentional. He testified at the second hearing. He intentionally missed this meeting with his probation officer, and he intentionally did not call them and tell them what happened because, he explained, he was scared. He was scared that he would go back to prison.
What would you say in the dissent, talking about that goes more to motive instead of behavior and just failing to report, but why he failed to report is irrelevant, because it's just still a failure to report.
Well, it's not irrelevant because this court said it wasn't irrelevant. In the first decision, this court said where he engages a course of action where he intentionally avoided probation supervision. So his intent, I think, is important. It's not irrelevant. He intentionally avoided his probation officer and intentionally avoided making contact with the community corrections to explain what happened because, as he explained, he was afraid of what would happen. And then when you go into December, when the probation officer kept trying to find him and located his girlfriend and told the girlfriend, hey, we're looking for him. You need to tell him he needs to get in contact with us before a warrant is issued. Mr. Dooley did not dispute that his girlfriend conveyed that information to him. In fact, he explained that actually he believed that a warrant had been issued for him. He didn't know for certain, he said, but he believed one had been issued. And when he finally turned himself in, the explanation he gave was he just had enough. Well, enough of what? Well, enough of living on the lam. He was tired of avoiding probation supervision. He was tired of bouncing around from shelter to truck stop to wherever it was he was staying. He said at the time he believed there was a warrant out for his arrest, so he finally just kind of gave up. But up to that point, it's clear that his intention was to avoid probation supervision because he was, out of his own mouth, he was afraid that he would be sent back to prison. So, his motivation for his behavior, I think, is important. It's one thing for a guy to fail to report because, well, he didn't have a ride, which happens, or he wrote it down wrong on the calendar, some inadvertence or something like that. But here we've got the stated motivation of Mr. Dooley was to avoid getting sent back to prison. So his motive is important.
Does that meet the definition of what we said in Robbins 1? Or what the parameters of abscond means is someone who departs secretly, withdraw oneself, hide, evade, avoid. It just seems like his conduct is somewhere in between what we're talking about, what abscond means and what is intended by that, and what occurred here.
Well, I think that Dooley took the Robbins language and refined it for the future here. And basically, what I read at the very beginning was right out of the decision. But basically, it's where if the state proves that he intentionally avoided supervision or evaded detection by his probation officer, that's absconded. And it said, I don't know if I can find the quote, but basically, it's not he can evade supervision by leaving the jurisdiction, but that's not, sneaking out of the jurisdiction is not the only way you can abscond. The court also said, I believe, that you can evade probation by hiding within the jurisdiction. And I would submit that that's essentially what Mr. Dooley did here. He hid within the jurisdiction. He didn't have a permanent home, a place to be found. He didn't have a job. He wasn't where he was supposed to be. He bounced around and made no effort to contact his probation supervisor.
So not having a place to live, being homeless, is absconding?
No. He could have called his probation officer and said, look, I didn't get into Oxford House. I don't know what to do. I'm going to go to a shelter. I'm going to go to the shelter, whatever shelter it is. That's where I will be. Is that okay? If he couldn't stay there, he could call the probation officer again and say, look, okay, I'm going to go to this truck stop where there's a hotel or wherever it was that he was staying. That wouldn't be absconding. By keeping it a secret, not telling anyone and bouncing around, that is absconding. That's why it comes down to not just the circumstance, which I think that's what the dissent in the Court of Appeals, I think, kind of where he missed the mark was he focuses so much on the circumstance. Well, yeah, the guy's got a rough life. He's in a bad circumstance, but that doesn't mean he can't pick up the phone and call a probation officer or walk into the probation office and say, hey, look, here's the situation that I'm in. I couldn't get in there. Okay, I'm going to go live with my girlfriend, or I'm going to go live in this halfway house. That's all he had to do. But the fact that he went for 2 months bouncing around from wherever it was he was staying, skipping his scheduled appointments with his probation officer, and then taking no action after his girlfriend told him that the probation officer was looking for him, and instead continuing to hide within the jurisdiction, I would submit is absconding. I mean, is it an obvious case where he, secured himself inside of the trunk of a car and sneaked out of the jurisdiction in the middle of the night and then lived on the lam? I mean, no, it's not that, but he was effectively hiding within the jurisdiction because he knew he had a duty to tell the probation office where he was. He knew he had a duty to meet with his probation officer. He knew he was supposed to be at the halfway house and he wasn't there. He eventually knew that the probation officer was looking for him because his girlfriend told him. And he said he suspected there was a warrant out for his arrest, but he continued to avoid his probation officer and community corrections because he was scared he would get sent back to prison. That is absconding. And I think in the record, I mean, there is substantial competent evidence to prove that. And I would, to touch on what opposing counsel had mentioned towards the end of his argument, I'm looking at the court's opinion. I mean, first off, this court said that in the first Dooley, that on remand, the district court can use Dooley's stipulations to the underlying facts. Dooley's agreement that he failed to report to community corrections or failed to report his whereabouts. I think the issue that my opposing counsel brought up was, well, he couldn't rely on the stipulation that he absconded, and that is correct. And the court did say in its ruling that he said, number one, he admitted that absconding at the originally at the probation hearing. But, and there's a significant but in there. The court says, but, two, he admitted that he failed to report to community corrections. He admitted that he failed to report his whereabouts to community corrections. He admitted that he intentionally failed to contact community corrections because he was scared. He evidently was living in a truck stop or shelter. It wasn't real clear which one, as he said two different things today. And he said the only reason that he finally reported was because he'd had enough and he had some belief that maybe there was a warrant out for his arrest. And so the court does find that the defendant intentionally evaded legal process by avoiding probation supervision. So the district court did not rely on that stipulation from the previous hearing.
But counsel, even in what you just read, if you take, the words after the but, there's 3 sentences that say he failed to report. He failed to report. He failed to report.
Yes.
How is it more? I mean, why isn't this just subject to 120 days? Why didn't the statute already account for this?
Because it was
violated by failing to report.
Multiple failures to report, and not just a failure to report, but a failure to be at the place where he was supposed to be, where his probation officer believed he was living, a failure to advise the probation office where he was, of his whereabouts and where he was living, and the fact that this failure to report persisted for weeks. It's not just a single failure to report.
Okay, so what would you have us then, in writing an opinion, if you were writing the opinion, would you have us say multiple failure to report equals absconding, or where would you have us draw a line?
Well, I don't think it's a mathematical situation where, X number of failures to report equals absconding. I think actually what you said in the first opinion about intentionally evading, avoiding supervision or evading the probation office, I think it has to be a course of conduct. So missing a single meeting with the probation officer wouldn't be enough, and I think it also wouldn't be enough if, he missed, if a guy was maybe out of contact for a week or something, if there was some reason other than avoiding legal or avoiding supervision. If a guy goes to the hospital and he's in a coma or he's in treatment and he doesn't report, well, that obviously wouldn't be absconding.
So it does hinge on motive. You would have us write on motive. And so
yeah, I think so. I mean, that's my reading of or my interpretation of this court's language in the first Dooley case. And I mean, obviously, if I'm wrong, I'm wrong. But that my take on it is the court said essentially it has to be an attempt to evade his supervision. So it could be, a couple of failures to report. It could, whatever it is. It has to be an evasion of supervision. So in this case,
if it turns on motive, then why wouldn't one failure to report, if it was intentionally done to evade reporting, okay, why wouldn't just one failure to report count as absconding if the motive was?
I think in some circumstances it could. Like I said, I don't think this is mathematical. For example, let's say, Mr. Dooley, I think he had to meet his probation officer December 6th. Well, if on December 4th, he hopped in a car secretly and fled to Mexico, and then was arrested on, December 7th, well, he would have only missed one meeting. He only failed to report once, but he fled the jurisdiction. He intended to avoid supervision. So, I mean, I think you could build hypothetical situations where maybe a single failure to report would be enough. I think most likely, the vast majority of cases, no, a single missed appointment wouldn't be enough.
How do we guide the lower courts then on this?
I'm sorry, I didn't understand.
I'm sorry. How do we guide the lower courts on this?
Again, I think going to the Dooley language, I think that the lower courts need to, basically, I think they need to look for a course of conduct that is intended to avoid supervision. And I think that's probably enough, because then, the parties can bring in facts that would support one way or the other. I think here we have, from Mr. Dooley's own mouth, a continuous course of conduct where he not only avoided or not only failed to report, but then also continued to fail to report and continued to report to advise where his living arrangements were. So it went on for weeks. And I think when you look at that, this is more than just one skipped meeting. Essentially, every day he failed to report, and he, out of his own mouth, he did it because he didn't want to get sent back to prison. He was afraid he would get sent back to prison if he made contact with his probation officer. So I think when you look at that, that's substantial competent evidence to support the district court's finding that he absconded.
Counsel, do you believe that the efforts of the probation officer add to the analysis or not? If so, how?
I think they do, because it shows it shows the probation was looking for him. But I think how it adds to it, though, is once the probation officer made contact with Dooley's girlfriend, and we know that loop was closed. Dooley admitted that he learned from his girlfriend that the probation office was looking for him, and that a warrant would be issued. That adds to the knowledge in Dooley's head and to his motivation. That's more evidence to show that he was attempting to evade supervision, because at that point he knows the probation officer is looking for him. So I think the probation officer's actions are certainly relevant. They're relevant especially to how it affected Mr. Dooley's behavior and whether or not he was evading the process. For example, if the day after he found out from his girlfriend that the probation officer was looking for him, he picked up the phone and called the probation officer, we wouldn't be here right now. But instead, he continued to avoid. And I'm out of time. If there are no further questions from the court, I would simply ask the court to affirm the Court of Appeals and the district court.
I see no further questions. Thank you. Mr. Ettinger, you reserve 2 minutes.
Thank you. May it please the court. I think the whole point of Dooley and Huckey, the idea here is clear that, and the rule is that you can intentionally fail to report and still not be absconding. And so again and again, you see intentionally failed to do this, intentionally failed to do that, failed to do this, but it all boils down to failure to report on all of these elements. And this notion that I think we're putting a few words into my client's mouth right now, as far as this idea that he had knowledge for certain that a warrant was issued. And even if he did, he was there a few weeks later. And this is kind of thing too, we don't have any evidence in the record that Mr. Dooley's carrying, and I think maybe that's what Judge Atchison is getting at. We don't really have any evidence here that my client's carrying a cell phone with him. There's nothing in the record whatsoever. There's nothing to even say who the probation officer called. He just says he called Mr. Dooley. There was no follow-up question. The follow-up question is, why didn't you send him a letter? And then also when Mr. Dooley's asked, were you aware that there was a warrant out? And Mr. Dooley says, I had a feeling. He said, you had a feeling? Yeah, but you had no specific knowledge. No, I didn't. So the idea that his girlfriend had contacted him and told him, hey, you got a warrant, you better go in. And he decided, oh, well, I'm going to go hide at a hotel somewhere in the same city that I've been in this whole entire time. That's just not supported by the record. He specifically testified, I didn't have any specific knowledge that I had a warrant. So I just wanted to clarify that as far as what the record supported in terms of my client's knowledge at that point. And I think if the court, unless the court has additional questions for me, I would ask it. I'm sorry?
Yeah, I do, counsel. I've been wrestling with this notion about, well, the dissent says he doesn't have to give deference to the district court because this is an error of law. And you say the same thing, but I keep getting back to there's got to be motive as a part of this. And so your last statement there where you indicated that your client testified that, he suspected that a warrant was issued for him, but he didn't know. If the court didn't believe that testimony, then don't you have absconding, which to me gets me back to we're really in a substantial competent evidence world, which means we've got to give deference to the lower court who looked this guy in the eye and made findings. And I mean, I'll grant you this is I find it to be a close call, but it seems to be a close call on the facts. And I think I've got to give deference to the district court. So talk me out of that, I guess.
Okay. Yes, Your Honor. I mean, the ultimate legal conclusion, of course, is a matter of law, that there is no need to give deference to that actual legal conclusion. Now, I understand that's hard to dissect because you need those facts to get to that conclusion. The only thing I can say in regards to your concern about the district court finding this credible or not credible, we have no findings by the district court in that regard. And it was completely, and the state even argued that. The state said, hey, I think this is the district court needs to take right now. They need to take notice of this is all self-serving testimony, all given by my client, Mr. Dooley. The district court didn't touch that. It didn't say, I don't find half of what Mr. Dooley is saying is false. I don't believe him. So I don't think that it's then this court's function to put those words in the district court's mouth or to make some obviously credibility determination at this point about Mr. Dooley's testimony.
I think maybe if the fact that if the court did not make a credibility finding, then my concern really sort of goes away. Because I mean, I can't read credibility finding into something that's not stated.
That's precisely my argument, that there's nothing here. I think you might have something more there if the court had made some finding. And on this record, I don't find this credible. And also it's backed up. That's backed up by the state asked the court to do that, more or less, which is common in many of these instances because it's usually the defendant that's on the stand to explain to them why he hasn't reported. So I hope that addresses your concern.
Thanks.
In Dooley, we quoted Robbins and adopted language from Robbins that says that it can be, the obvious evasions by secreting, that type of thing. And then they add, or because a pattern of violations permits the inference that the defendant is intentionally evading the legal process. And what I'm kind of building on this question of fact versus law, the district court here did make a series of findings about what could be called a pattern of violations. And so how do we say that this pattern didn't fit within that inference that we have said is a permissible inference to make to reach the conclusion the district court reached?
I think I'd have to respond by going back to what was sort of touched on earlier, this idea that that's fine. The district court can make all those findings, and then the result is that he has to impose 180 or 120-day sanction. Where in this case, I guess the argument is that this doesn't rise to the level of absconding. So there was that's what should have happened originally, if I'm understanding what you're asking.
Well, no, I mean, what we say in Dooley really is that if there is a pattern, the judge can infer that that's an intentional evasion of legal process. And the words that follow that is then the defendant has absconded from supervision.
Right, and I know that the Court of Appeals did say, and it's sort of piggybacking on this idea of a permissible inference that's there. And I think what I guess it is we're still kind of arguing the facts here. I think that, you know, Mr. Dooley, and that's why I started with the fact that Mr. Dooley came into the corrections office. He wasn't arrested on a warrant committing an additional offense. He wasn't, you know, something along these other lines where he did everything he could to evade process for as long as possible. And the record would then show that this individual's intent in the average case, I think, if it rises to this level where we can show that this individual's intent over this, you know, certain amount of time is clear that that's what they were trying to do, that's belied by the fact that, you know, Mr. Dooley came in to report only a month or so after that warrant was issued. I think he was supposed to report in December. He came in January. I know it wasn't very long at all. And so this brief, the distinction is between an intentional pattern that shows that you are trying to evade process versus a series of just failures to show up where you're supposed to be. And I'd say that the fact that Mr. Dooley actually came in just a couple weeks or several, you know, a few weeks after this warrant was issued, even though he wasn't sure if he had it or not, really cuts to the point that goes to his motive and his indication. He was scared. He wasn't trying to avoid process. He was, I would argue that he was coming to terms with the fear of the fact that I'm going to go to prison. Not that I don't want them to ever find me, and I'm gonna hide out here as long as I possibly can. I don't think that the record supports that at all. I hope that addresses your question, Your Honor.
Thank you. Are there other questions? Thank you, counsel.
Thank you.
And
I would just ask for the court to reverse the district court's finding and remand if necessary, Your Honor. Thank you.
Yes, certainly. Yes. Thank you to both counsel for your arguments today. We will take this appeal under advisement. The court is now in recess until 9 a.m. tomorrow morning.